So this is a webinar hosted by the European branch of the Chartered Institute of Arbitrators. I'm here with a very distinguished group of panelists. We're going to be speaking about comparative corporate arbitration law. So my name is Philipp Landolt, and I'll just share with you our biographies on the screen. My name is Philipp Landolt. I'm an arbitration practitioner based in Geneva with the law firm of Landolt & Koch. I'm also the chair of the European branch of the Chartered Institute. Our speakers today, in order of appearance, are the Honorable Barry Leon, who's a fellow of the Chartered Institute. So Barry is a former presiding judge of the Commercial Court of the Eastern Caribbean, notably the British Virgin Islands, which you'll recognize as a very, very important jurisdiction for corporations. And Barry has a very important career before that at one of Canada's premier law firms, Torys, where he actually led the litigation and arbitration department. Barry is very knowledgeable about corporate law and common law systems, and today he will be speaking about, well, generally, he'll introduce matters of limitations on who can arbitrate. In particular, Barry will be speaking about Ontario and UK arbitration law, but also about Brazilian arbitration law. We next have Dr. Philipp Massari, who practices with the law firm of Massari and Ulbrich. Dr. Massari is a German lawyer, and he has this particularity about his profile. He's an expert both in corporate law and in international dispute resolution. He'll be giving us the German perspective on corporate law, a very important perspective. As you know, German corporations are very active in arbitration around the world. We'll next hear from Dr. Roberto Oliva, who is a partner at the Milan law firm of Pavia and Ansaldo. He is a very experienced arbitration practitioner, and he has run many cases as both arbitrator and counsel. He is a very capable secretary of the European branch of the Chartered Institute of Arbitrators. Roberto will be speaking about the Italian perspective on corporate international arbitration law. We next will hear from John Lowe. Now, John is an American, called in both DC and Ohio, an arbitration practitioner. He's based in Paris, and so John will be giving us the French perspective on corporate arbitration law, but also the American perspective. We're delighted to have our presenters here. I'll turn now to our topic. So you probably know there's an awful lot of M&A arbitration out there, but that's not what we're going to be focusing on today. M&A arbitration involves inter-corporate arbitration, so arbitration between different legal entities, one towards the other, separate legal entities, separate corporations, separate legal persons. But what we're going to focus on today is intra-corporate arbitration. So these are going to be arbitrations effectively involving persons involved in the same legal person, same corporate entity. For example, shareholders taking action against directors or auditors, et cetera, et cetera. This is quite unique in as much as it raises a lot of very knotty arbitration issues, more so than M&A arbitration does. And this is the particular interest here. It's not a field that has been well sifted through. There's not a lot on it. It hasn't been really studied as much as its, let's say, its inherent interest merits. And today we're going to try to lay the groundwork for what the sort of issues are in corporate arbitration. And we're going additionally to compare how our various jurisdictions approach them. I wanted to say that it's going to be initially Barry looking at Barry's going to look at the subjects of intra-corporation arbitration. Then we're going to hear from first it's going to be Philip looking at the persons involved in intra-corporate arbitration, and then secondly, Barry on the subjects of intra-corporate arbitration. We're then going to hear from Roberto on procedural particularities of intra-corporation arbitration. And lastly, we hear from John, who is going to present to us a perspective on whether, given all the challenges in intra-corporate arbitration, it's actually really worth it. At that point, we're going to start analyzing various aspects of intra-corporate arbitration and assessing, the various issues from the comparative perspective. I wanted to mention that all of our presenters today are men, but for our next webinar, all the presenters are women. So at least across our webinars, there is going to be gender diversity. So without further ado, I'll ask Barry to be, sorry, it is Philip, isn't it? Sorry.
So just before we begin, if people have questions, should they put them in the Q&A?
Yes, thanks, Barry. Yeah, so if you have any questions, you're very welcome to ask them. Please just do that through the Q&A. I disturbed the order. It's actually Philip beginning. Let's revert to the order we agreed on. Philip is going to discuss the particularities about jurisdiction and effectively the persons who are involved in intra-corporate arbitration. So Philip, please do give us a view on these matters.
Absolutely. Thank you, Philip. So who is subject to an intra-corporate arbitration clause? Well, usually the answer to the question who is subject to an arbitration clause is very straightforward. You have a contract, you have two parties, the two parties signed the contract contains arbitration clause, so these two parties are subject to the arbitration clause. Very easy and straightforward. However, it becomes much less easy and much trickier when you have an intra-corporate arbitration clause, because this clause is not in a contract between two parties who have signed it, but it's in the statutes of a company. So the question is, who is bound by the statutes of a company? Also, that might seem very clear at the beginning, but can become very tricky. So let me give you some examples. If you have, of course, all the shareholders having anonymously agreed to these statutes, have signed them maybe, or agreed to them in the way that is applicable in the jurisdiction, then of course all these shareholders are bound by this arbitration clause. But what about future shareholders? So often, as you know, shareholders change all the time. And if you have a new shareholder coming in, did that shareholder implicitly consent to the statutory arbitration clause by purchasing shares of the company? I don't want to imply that is the case. It's not the case, because that very much depends on also the jurisdiction and maybe some other questions. It's just one issue that comes up when you talk about intra-corporate arbitration clause. Furthermore, to add a more layer of complexity, in some jurisdictions, statutory arbitration clauses can be introduced by a majority vote. So you have a clause in the statutes that has been adopted by a majority vote. Not everyone has consented. You might have minority shareholders that have expressively opposed this clause. Are they still bound by that? Again, I don't want to answer this here in any way, just saying these are some of the questions that come up in this context, and the answer will depend on the jurisdiction, and we'll discuss that a bit. We will discuss that further later. Another question is the corporate bodies of a company, like directors, officers, managers, board members. So those are usually also bound by statutory arbitration clauses. But does this also apply when you have a case, as you might know, have a de facto decision maker? So you have someone who has never been officially appointed a director, an officer, or any other official, but is just de facto the one who makes the decisions. Is this person also bound? Furthermore, are members of corporate bodies still bound by a statutory arbitration clause when they had already resigned years ago? So you see there are a lot of questions that come up and which pose questions which are very different to the commercial arbitrations we are used to. And that makes it very complex for already to decide, or might, depending on the case, obviously, who's bound by the statutes of a company. Having said that, I think now we'll move forward. That was what I wanted to cover on the subjects. Now we move forward to Barry, who's going to talk, I think, about what are subjects of the arbitration. So not who are the subject, but what is the subject.
Thanks, Philip. Yes, that's what I will talk a bit about. And the starting point that I like to think of it as with all arbitration, everything is arbitrable unless the law of the jurisdiction of the seat or the law binding the agreement, or in this case, the corporation, makes it otherwise. So in theory, all of the disputes should start by being arbitrable, but they're not. And the difficulty comes is that we're not talking about a contract. We may be talking about a contract if we're talking about disputes under a unanimous shareholders agreement, but if the arbitration agreement comes through the corporate instruments, the incorporating document, the articles, or in some other form, then it gets a little more complicated because everyone hasn't actually signed it. So there's some subject matters that go beyond the interests of the parties and affect third parties, or their disputes that affect something in rem that is against the world. So thinking about the kinds of disputes that we could be talking about there, an easy one would be winding up the corporation. And I will talk at some point about the remedy, statutory remedy that exists in many common law jurisdictions, referred to as unfair prejudice or oppression. But those that's a statutory ability, a remedy, not particularly referring to who decides it, but gives rights to people affected by acts of a corporation or a majority of a corporation. And so in some instances, the remedies can include things like winding up the corporation. Other corporate functions that courts sometimes get involved in is restoring a company to the register. In some jurisdictions, the company can be removed from the register for various reasons, whether it's not paying fees or not having directors in place, those kinds of things. Those things generally would be something affecting more than the people involved in the corporation. So there's those group of corporate actions that can't be arbitrated, or at least the remedy can't be provided by an arbitral tribunal. And then you get a more complicated aspect, and that's where the third parties are affected. They're not necessarily, so those would be the public, employees. Are there some kinds of corporate disputes that have a significant public interest or a sufficient public interest that they shouldn't be left to tribunals? There's an example in one Ontario, Canada decision where it was an arbitration agreement, but involved the what there is referred to as the blue box, but the recycling system for the jurisdiction. And so the arbitral tribunal did the kind of thing that you might see in an investor-state arbitration, and that is designed an open process, and you could have a process where the public has the right to make submissions in some form or another, a amicus intervener type process. So, but those are areas where the subject matters raise a public policy question as to whether they should be arbitrable because the public is affected. And then there are situations, and I'll talk later about something that Brazil has done, but in essence, where the law of the jurisdiction has given tribunal rights to decide things that ordinarily they wouldn't have. So it's the opposite of what I was saying before, where the law says you can't arbitrate. This would be something where the law says you can arbitrate. And in Brazil, the situation relates to corporations and public corporations of a certain type. In jurisdictions that have trusts, and then sometimes you'll have business entities formed through a business trust, and then you also have private trusts. Some jurisdictions, and most notably Bahamas, has given to, by legislation, has given to arbitrators powers that ordinarily courts would have. So you could have that happen with corporate disputes as well. And the Brazil example may be the closest that I can think of. It comes up somewhat with the oppression or unfair prejudice remedies, where the courts have said that there's the claim can be determined by an arbitral tribunal, but then you have to look at what remedy is sought, and some remedies can be given by the tribunal, but some are reserved for a court. And to end on this topic, in those kinds of situations, you may need or want in the jurisdiction specialized rules. And we will talk later about the specialized rules for corporate disputes in some jurisdictions, but those can solve some of these public policy, public interest issues by giving rights that ordinarily wouldn't exist under arbitral rules. So, Philip, that is a bit of an overview of subject matters, unless anybody on the panel can think of a subject matter that I should have dealt with and didn't.
I think, it's a wide open field, but I think you've touched on some important ones, Barry, and thank you for that. We'll perhaps develop these matters subsequently in our discussion. At this stage, therefore, I'll ask Roberto, please, to raise some of the procedural difficulties involved in intra-corporate arbitration. And I just want to remind everybody that you're most welcome to ask questions at any point, and we'll field those questions at appropriate times. You can do so by using the Q&A. Roberto?
So, thank you, Philip. I would say that almost all issues concerning procedural matters arise out of the nature of corporate arbitration. As Philip mentioned a few minutes ago, this arbitration does not involve a dual relationship, such as a contract, where you have a seller and a buyer, a worker, an employer, a principal, an agent, and so on. We have a complex multilateral relationship with multiple and potentially conflicting interest centers. The majority shareholders, the minority shareholders, the directors, the statutory auditors, and so on. And this complexity obviously affects the procedural rules, as arbitration is not designed to address such a situation, and therefore some changes are needed. I am informed that some specific rules were enacted regarding corporate arbitration, for example, in Switzerland and in Germany. And Barry also mentioned the Brazilian rules. Nonetheless, in my understanding, they are very recent rules. In Italy, in my jurisdiction, we had similar rules for more than 20 years. They were enacted in 2003. And so we could examine them also in the light of their interpretation provided by the Italian courts. And so the first problem, Philip already mentioned it, who is bound by the arbitration clause in the article of association of a company? And I would add, are its binding effects in compliance with the principle of privity of contract, whereby a contract does not have and cannot have effects on parties other than the stipulating parties? From the Italian perspective, the answer is pretty simple. The clause is binding on the shareholders, and they are bound by the mere fact of being or becoming shareholders, because this fact amounts to an acceptance of the arbitration clause. And in addition, if the clause scope of application also includes claims by, raised by, or towards directors and statutory auditors, they are bound and deemed to have accepted the jurisdiction of the arbitral tribunal when they accepted their appointment. The Italian case law is very clear in following these principles. And so, second problem, who is entitled to take part in the proceedings? Once again, we have a clear law rule. All stakeholders are entitled to join the proceedings, and they can join up to the hearing. And another law rule states that the company is required to publish all the requests for arbitration it received in the local company's house. These requests are only accessible to the shareholders, but this way they can be informed of the proceedings and join them if they wish. So, third problem, how do you appoint the arbitral tribunal? We have another clear law rule. The Italian lawmakers choose to cut the Gordian knot. All complications are removed as a third party appoints all the arbitrators. So the identification of such appointing authority is of crucial importance, but you do not have to distinguish between several cases just to understand how to appoint an arbitral tribunal. Should mention that some scholars try to circumvent that rule, asserting that could be argued maybe that in some cases it could happen that the arbitral tribunal could be appointed by the parties. But these attempts were repressed by the Italian courts a long time ago in the early 2000s, and now there is no doubt that in all cases of corporate arbitration, all the arbitrators are to be appointed by a third party. Fourth problem, maybe the most interesting problem. Corporate law is an area where a conflict of interest could arise. Let's assume, for example, that a minority shareholder challenges a decision of the general meeting. So the claimant is the minority shareholder. The respondent is the company. But the company must act through a natural person. And this natural person, the director of the company, also happens to be the majority shareholder. So the same natural person who voted for the deliberation, the minority shareholder claimed to be unlawful. And Italian law provides that in such cases, the company could be represented by a trustee. The Italian term is curatore speciale, special trustee. It is quite complex to assess if there is an actual conflict of interest or not. And I'm not going to address this topic. But the question I would like to pose now is another. Who is entitled to appoint the trustee? The arbitral tribunal, the state court acting as juge d'appui, the state court in any case. This is a point on which there is no clear guidance. I have an idea, but I cannot share it with our audience as I'm currently involved in arbitration proceedings where this point is relevant. The sole thing I could say is that if the trustee is appointed by the wrong authority, that could have significant effects on the arbitration. The award could be set aside, and it could even happen that the claimant is no longer entitled to raise the claim due to the statute of limitation. So it's a very relevant question. And finally, the fifth problem. This is the sole problem I'm going to mention today that does not concern the party. The sole problem which is not a consequence of the plurilateral nature of corporate arbitration. Is it possible such a thing as international corporate arbitration? Italian law, but I assume that the same applies to every law, is full of mandatory provisions in corporate law concerning both the merits and the procedure. So that should prevent international corporate arbitration. That is to say, arbitration proceeding corporate matters concerning an Italian company, but seated outside Italy. But as it often happens, the first impression is wrong. There is at least one precedent, a decision of an Italian court allowing the enforcement of a foreign award, which was an award in corporate matters issued in corporate arbitration involving an Italian company, but in proceedings seated in Switzerland. And so to sum up and to conclude, there are some procedural issues in the sense that some problems are yet to be addressed and resolved. In my view, from an Italian perspective, the main problem is that concerning the appointment of the trustee. But for the rest, there are more peculiarities than issues. They were issues 20 years ago, but in the meantime, our scholars and courts addressed and solved them. And so it is clear the reason why at least 1/3 of Italian companies have an arbitration clause in their articles of association. The law is quite stable, its meaning is quite clear, and you do not have to wait the time of Italian courts to get a binding decision.
Thank you, Roberto. Okay,
You're
so
welcome.
we've heard now from Philip about who can arbitrate intra-corporate disputes. We've heard from Barry about the subjects of intra-corporate arbitration disputes. And we've heard from Roberto about procedural aspects of intra-corporate arbitration. I noticed that each of you naturally has focused on the jurisdictions you were asked to focus on. And I was wondering if it might be an idea after John speaks about his topic, that we fill our information out by each of you having an opportunity to speak on each other's topics. And for example, Barry might say a few things about standing or who has jurisdiction to arbitrate intra-corporate disputes in the UK, in Ontario, et cetera. Philip on subject matter, Roberto on these other two topics, et cetera. Just I want to flag that I'll be inquiring about that. So if you do want to intervene, just to fill out the information for our audience, you'll have an opportunity to do so. At this stage, we'll ask John Lowe, please, to discuss the question about, in view of all these difficulties that our three other speakers have raised, is there a positive case for intra-corporate arbitration? John?
Thanks, Philip. Can you hear me? I guess you can. Okay, I'm going to look at this from the perspective, again, I'm an American lawyer based in, I've been in Europe a long time, but I think probably more importantly for the purposes of this conversation is I've also been a long time in-house counsel and general counsel at a number of international companies. So what the question I impose, or I started asking myself when we started discussing this topic is, under what circumstances and why might I try to convince maybe first the board of directors that we need to change our articles of association, our bylaws, to incorporate arbitration as a means of dispute resolution? And I think as I started looking at it or thinking about it, I would probably like to go back a little bit. I would probably do it in more of a step-by-step approach. The first thing I would like to point out is that in most companies, essentially medium-sized or even large companies with a global presence, there are many, many types of intra-corporate agreements. These can be IP agreements where all the IP is placed in one jurisdiction and royalties are paid. There can be revenue sharing agreements. There are pooling agreements. There are a myriad of intra-company agreements. And frankly, if I'm starting to think about introducing arbitration as a dispute resolution mechanism into a corporate entity, I would probably start not at the Articles of Association or the bylaw level. I would probably start at those intra-corporate agreements, because what you're trying to do as a general counsel is you're trying to develop a case for convincing the board and possibly eventually the shareholders that what you want to introduce is actually beneficial. And the reason you would be doing this is mostly for cost and efficiency reasons. You'd want to be able to tell them that if we do this, if we introduce arbitration clauses into these corporate documents, into our shareholders agreements, into our articles of association, into our bylaws. And again, I'm using a number of different terms, but essentially what I'm talking about are those documents which govern how the corporation works. If we're going to introduce arbitration clauses into these agreements, it's going to have to be justified on the basis of cost and efficiency. For example, I've dealt with corporate disputes in the state of Delaware, and I'm coming to mind, and Germany is the one that's coming to mind right now. And from a court perspective, Delaware moved much, much more quickly than Germany. So if I had a German company, I would probably start looking at arbitration for my corporate disputes simply because you might be able to do it more quickly and more cost effectively rather than trying to look at a jurisdiction like Delaware, where frankly the chancery courts move relatively quickly and have a very well-developed body of law. That being said, so these are the issues that I would look at. If you're trying to convince your board of directors to enter, what are some of the other advantages might be confidentiality, might be speed of the dispute resolution. But again, having dealt with lots of boards and lots of shareholder groups, as a general counsel, in-house counsel, you need to be able to convince your management that what you're doing is going to bring tangible benefits to the company. And I'm not going to get into it right now. We'll talk about it a little later. One issue that's arising in the United States is the possible use of arbitration for handling shareholder disputes, both in privately held companies and possibly even more importantly in publicly held companies. And this is partly to deal with the issue of derivative actions, whereby shareholders bring an action against the company on behalf of all other shareholders. And these actually can result in very expensive payouts to the shareholders bringing the derivative actions. If you were able to get an arbitration clause into your corporate documents, you may be able to at least mitigate some of the costs associated with this. But again, I think there are potential benefits to having arbitration in your corporate agreements. I would say, just going back to what I said earlier, you would start by trying to get some of these agreements into your other intra-company agreements, maybe before moving to the corporate agreements. But again, you would also look at it very much on a jurisdiction by jurisdiction basis, and trying to decide, are there going to be cost and efficiency gains? I think I'm going to stop there, and we can see what questions we have or what comments from my panelists.
Right. Thanks, John. Oh, yeah. So as mentioned, I think it'd be helpful if we went back to the various topics and added other perspectives from other jurisdictions, starting from the first, who is subject to arbitration. I'll just note that, as everybody has heard, the genesis, the origin of intra-corporate arbitrations is going to be something like a constitutive document for the corporation itself, articles of association, et cetera, et cetera. And so you have this very important document, and you can see it affects the whole corporation, as a constitution affects the whole country, and what it subsequently does, its subsequent actions. And from there, you can see that there are real issues about who's bound by that document. For example, our future shareholders, Philip touched on that, future shareholders. Are they bound by the constitutive document, which they weren't involved in developing? Minority shareholders, we've just heard about oppression remedies, de facto decision makers within the corporation. You're not a director formally, but you happen to wield huge influence. Does that attract you into the arbitration clause? Persons with functions that have been discontinued in the corporation, like founders, creditors, commercial registries. So we've heard the German perspective from Philip. I was wondering if from the other national perspectives, there's something to be added, and I'll leave it open amongst the panelists to comment as you'd like.
If I may start just to add a bit more specifics on the German perspective. So in Germany, at the outset, you need to know that there's no special legislation on that. So there's only court rulings which basically determine what you can do and can't do. And it's very questionable whether it's possible to have it in a company limited by shares, meaning usually you have it in smaller companies, smaller size companies, limited companies or partnerships where you find these clauses. And there's this strict ruling by the Federal Court of Justice. There's, on the one side, allows statutory arbitration clauses, but requires agreement by everyone. And so I think the question specifically for future shareholders, I don't think that came up so far. And I think the reason why it didn't come up so far is because you have usually smaller settings where if you buy, shares, you know what you're buying into. And it's not like a big corporation where, you buy shares at a stock exchange even or somewhere, and then you find yourself confronted with arbitration clause. However, if that question came up, I'm not sure the Federal Court of Justice would see this as a sufficient agreement. At least there would be significant doubts on that.
Thanks, Philip. Any other comments on this issue?
Philip, it's John. The one thing I would say, and again, I'm sort of echoing a little bit what Philip Massari just said, is it depends a lot on the size and the complexity of the company, and essentially, to a certain extent, how many shareholders are there are. I'm thinking, for example, in the area of private equity companies or venture capital companies, there are actually usually a limited number of shareholders, and everybody knows what they're signing up to, particularly when a private equity company gets involved. There are also usually lots of changes to corporate documents. So that actually is a good time to possibly introduce arbitration clauses. And again, these are private companies, so there's not the public aspect. And it's actually easier to implement these agreements. And as Philip said, people know what they're signing up to. They are basically required to sign up to fairly sophisticated shareholder agreements. So this is a type of situation where arbitration dispute resolution methods could be of great use.
Thanks, John. Anybody else?
Well, I was just going to add the question, I guess, comes up is when you're dealing with something other than what John was talking about, what note, and it's been mentioned by a couple of people, what notice does the shareholder need to have when the shareholder isn't part of the original incorporating group but buys into shares? So if you're buying shares of a company that's subject to a unanimous shareholders agreement, you're going to be required to join into that agreement as part of buying the shares. If you're buying shares and there's a provision in the bylaws, are you taken in your jurisdiction to know what's in the bylaws, or does there need to be some express notification? And I'm thinking of some of the issues that come up in consumer arbitration or those kind of situations where courts have basically said, the shrink wrap arbitration clauses, that it's unfair, even though the arbitration clause is there, it's unfair because the person wasn't appropriately notified of it. And it comes up if somebody brings a court action and then you're trying to have the matter moved to arbitration because there's an arbitration clause. Is this a situation of unfairness? So that may need to be addressed in some situations. It is addressed statutorily or regulatory in some places. And I don't know, Philip, if it might be a good time just to mention what the Sao Paulo Stock Exchange has done. If you've got want to screen share that,
Is that the Ontario one? Yeah.
No, it's the Sao Paulo Stock Exchange.
Sao Paulo Stock Exchange, got it.
So there's this is very short, but the part that's highlighted, the arbitration let me start at the beginning. I jumped ahead, I think. Certain kinds of corporations are required if they're going to be listed, and these are larger corporations on the exchange, to have these things in their bylaws. It says that the B3, that's this category of listed company, must provide for arbitration in their bylaws. So it's a requirement. If you're going to be one of those companies and listed in this category, you have to have arbitration. And then it's administered by the stock exchange, as it says. And the admission to the market arbitration panel is the last point. If you just scroll up a bit, admission to the market arbitration panel for resolution of corporate disputes is one of the criteria for listing. So that
document, Barry, sorry, do I have the right document on the screen?
You have the right document, but just at the bottom I was reading.
Very bottom. Okay, sorry, apologies. Right in here. Yeah.
And just scroll. If you can you bring the document up?
To the top, you mean?
To the bottom.
The bottom, right down here.
Further down.
It's the last part of the document, but I can just read it. We don't need to see it. So, but the point being that the stock exchange, the Sao Paulo Stock Exchange, has imposed an arbitration requirement for listing on the exchange in a certain category, that there must be arbitration of and these are public companies, must provide for arbitration in their bylaws. So that solves the problem in that situation of that I was just talking about, the notification or the awareness of the fact that you're not in court, you're in arbitration for the resolution of disputes.
Yeah. Okay,
It's
terrific.
quite curious, as in Italy we have the opposite rule. All Italian companies, but listed companies, may have an arbitration clause in their article of association. And the underlying reasoning is that an arbitration clause could prevent the minority shareholders to raise claims against the majority shareholders or the directors of a listed company.
Okay. Philip, this is John. I see we're getting some questions. How do you want to handle these?
Yeah, let's close off this part and then we'll look at the questions. I think they're going to require some interpretation, but let's do attend to the questions. Absolutely, John. Many thanks. Okay, well, I think we've looked at what they call jurisdiction ratione personae, and sufficiently for now. And what about the subject matters of intra-corporate arbitration? Barry's spoken about this. I wanted to give you all an opportunity to provide your country's perspective, the one you're responsible for, on this issue. You've got this arbitration clause in a corporate document, an important one, Articles of Association or something. I mean, whom does it reach? What topics does it reach? What sort of issues would it cover from these other national perspectives, and which will it not? Yes. Okay. So, for example, what if someone contests the very existence of the company? Is that arbitrable? What's the analysis? It's this venerable arbitration principle, isn't it? That you have competence. Does that apply in the intra-corporate arbitration area as well?
One would have, I guess, may depend on the nature of the complaints. I would say you go back to that principle that is it something that is by agreement, or is it something that relates to the state? So if the state requires that you pay a filing fee and you haven't paid your filing fee, or that the incorporating documents have to be signed in a certain way, that seems to be a matter between the incorporators or the corporation and the state, not among shareholders, because there's a public interest. But there may be other situations where it really is a matter, the issue is really among the members of the corporation, the shareholders, or whatever the entity formation is.
Yeah, absolutely. It's an important distinction. So generally speaking, the validity. Yes, Roberto. Sorry.
Yeah, I would say that from an Italian perspective, we have a pretty clear rules. So if the claim is based on the corporate relationship, it falls within the scope of the corporate arbitration. Otherwise, if the corporate relationship is just the background of the claim, it does not. The rule is clear, but sometimes the application could be a little bit tricky. So, for example, what about a shareholder loan? I know the answer because there are some decisions by Italian courts, but from a theoretical point of view, the answer is not so obvious, because the shareholder loan is not solely based on the corporate relationship. There's something more. There's a loan agreement. But we have case law that says that the corporate relationship is not just the background of the shareholder loan, but is the true net of the shareholder loan, so it's subject to corporate arbitration. I think that we have a case-by-case analysis on some particular relationship that was done in Italy in 20 years, and I think that it will be done in other jurisdictions where corporate arbitration is now more used.
Roberto, another example might be employment. So it's agreed among the shareholders that Roberto is going to be the chief executive. Is that an employment agreement with the corporation, or is it a matter among the shareholders? Those kinds
In
of
Italy,
things.
it's a mess also because we have specialized chambers on corporate matters and on labor matters. So there's a number of possible venue for this kind of disputes.
I actually, Philip, I was related to that. Was involved in one arbitration in the US under Delaware law, where it did involve something very similar. And this, it involved the termination of an employment agreement, but it was actually a termination of somebody who had a significant holding in the company. And the shareholders agreement provided that in the event the person no longer worked for the company, then they would be required to divest themselves of their shareholding. And then the question became, at what value might that be, the divestiture, would it take place? So these are actually what I would consider some of the common types of corporate issues. What restrictions are there on the sale or transfer of your shareholdings? And closely related to that is, what is the value that is going to be attributed to those shares or holdings?
I was involved in a similar case years ago. It wound up in court to begin with, and Air Canada was the majority shareholder in 2 regional airlines. And the agreement had provided that when the person who had was the CEO of those regional airlines was terminated, they'd have to the minority interest would have to be sold to Air Canada, and they triggered, and the court found this, they had triggered the termination of his employment for the sole purpose of being able to buy out the shares. And the issue became whether the arbitration clause applied to that or not. But the details aren't so important, but you can see how these kinds of issues can become complicated when you've got these overlay of other kinds of relationships.
Yeah, absolutely. Yeah. So a big issue is the validity or legality of the resolutions of a corporate body. Is that caught by an arbitration clause in the Articles of Association?
If I may jump on that, so that is what's typically in Germany considered intra-corporate dispute, the validity of a resolution, and that is the case because the rulings of the Federal Court of Justice are all around that. So, and everything, and that is now, after 4 rulings we had on this issue, is well settled. There are the rules of the German Institute of Arbitration which cover that. So when we talk about what can be subject, I mean, it's obvious to state the obvious. I mean, it depends on the clause you have, but the clauses you will find in Germany will usually cover that, meaning disputes between the company and shareholders or between shareholders among themselves. And that's usually the validity of resolutions.
Yeah, the same here in Italy. And this matter concerning the validity of resolutions by corporate bodies was the first matter in which Italian arbitral tribunals were allowed to issue interim measures. Now, Italian arbitration law was reformed, and in all matters they are allowed to issue interim measures. But the first matter where they were allowed was corporate matters, and in particular the resolution of corporate bodies. In a nutshell, Italian arbitral tribunals had the power to stay a resolution.
There's a different issue I was going to raise. I'm not sure if it falls under this subject matter, but I guess it depends how you characterize it. There's there's an English decision which came up whether an English court can order a remedy. In that case, it was a buyout in respect of a foreign company. So arbitration seated in London, corporation incorporated somewhere else, and the court found, it was a first instance decision, that even though an English court was not in a position to order that remedy, if the proceeding had been in court, that an arbitral tribunal seated in England could. And so it comes up obviously on all of these questions. There may also be recognition and enforcement issues that we can talk about separately, but at least in terms of the jurisdiction of the seat, the English court said no, the arbitration clause was sufficient to say that the dispute is arbitrable, and the parties had chosen a seat other than where the corporation was incorporated, and the matter went ahead in arbitration, and the remedy was granted and upheld.
Okay. Another issue that may or may not be subject to intra-corporate arbitration. What about deficiencies in the corporate organization? So there's a problem in the corporation, and a shareholder wants to have that remedied, or someone else wants to have that remedied, and there's, for some reason, a lack of movement. Is that the sort of thing that can be subject to arbitration?
Well, I would have said if it's among the shareholders, it can be. If it's not involving, in the way you've described it, it sounds as though it's an issue among shareholders or members, whatever the terminology is. So as long as it's, I would have said, at least in common law jurisdictions, if you're not affecting the public, if it's not an in rem matter, or if it's not something that directly involves somebody that isn't in effect party to the arbitration agreement or party to the corporate document that provides for arbitration, then it's arbitrable. So all of the machinations that go on in a corporation around decisions to issue shares, to dilute, to provide information, not provide information, that all of those things would be arbitrable, I think in most common law jurisdictions, at least.
Okay. Is there any distinction to be taken between a statutory remedy and on the one hand, and say a contractual remedy on the other, in terms of whether they go to arbitration?
Or are you thinking of the kind of statutory remedy that I mentioned of
Yes.
unfair prejudice or oppression?
Yeah.
I mean, I think what I'd like to do at an appropriate time is just, we've got a couple of slides on that, is just explain for those people who aren't familiar. It exists. That remedy is a statutory remedy that exists in most common law jurisdictions, in the UK, Canada, Australia, Hong Kong, Singapore. I'm told that some of the US states have that type of a remedy, but I'll defer to John on the US. So if you want, we could put up one of the slides, and
I think this is an appropriate. Yeah, sure. Where are we going to start then, Barry?
Why don't we just put up the easy one is they're similar. The UK Companies Act, because it's a short slide. So section of the Companies Act. Oops, we lost it there.
Yeah, let me just find it again. The UK Companies Act. Yeah, okay.
And there it is. So this has nothing to do with arbitration. It's a remedy that's given, a statutory remedy that's given. A company member may apply to the court, and the basis is, and it's, you can see it in A, that the company's affairs are being or have been conducted in a manner that's unfairly prejudicial to the interests of members generally or some part of the members. And then I don't know if you can bring the slide down, but it goes on to say that an act or omission of the company is prejudicial. And it provides that the person, the complainant, can apply for a remedy. And it can also applies to a person who's not a member of the company, but whose shares have been transferred or transmitted. So, but the basic remedy is that broad. It allows an application for relief, and the Ontario version and other jurisdictions have greater or lesser amounts of detail, but the kinds of remedies are similar. And I don't know if you've got that slide, but I can just give an example of the kinds of remedies, because in the Ontario statute, if you bring up the bottom part of that, or there, court order, that's the part. So if you go just to A, no, other way, there we go, stop, good. May make any more final order thinks fit, including, and it goes on to list, it goes A to M, but restraining conduct, appointing a receiver, amending the articles, directing an issue or exchange of securities, appointing directors, directing the corporation to purchase securities, so that is to buy out the shareholder, pay money owed to a shareholder. H is vary or setting aside a transaction or contract to which the corporation is party, and goes on to say ordering production of financial statements, compensating an aggrieved person, rectifying registers or other records, winding up the corporation, directing an investigation of the corporation, and so on. So there's a broad series of remedies. The English Act doesn't list them in the same way, but it's got broad wording, and the jurisprudence allows for it. So then the question becomes, which of these things can an arbitral tribunal order, and which things have to be ordered by the court? And the courts have essentially found that an arbitral tribunal can determine whether there has been oppressive or unfairly prejudicial conduct. So the liability can be established by a tribunal. And secondly, the tribunal can grant remedies, but not all of those remedies. So the most obvious one might be winding up the corporation, or ordering an investigation. There's probably a difference. I would take a broader view and say that, or ask the question, can some things be done by ordering people to do it, even though there isn't the ability of the arbitral tribunal to actually order it? But then you get to the question of, is that affecting other parties, creditors, non-parties to the arbitration? And where do you draw the line on which remedies a court has to invoke? And then there's been some suggestion that says you could design a clause that's sort of a hybrid, that has the arbitration tribunal determine liability, ability to determine all these remedies, but then if other remedies are to be considered, the matter is taken before a court to determine if those remedies should be granted as well. So that gets into the drafting of the arbitration clause, but those are the boundaries. I think it's important because the remedy exists, as I said, in all or almost all common law jurisdictions, and when we come to talk about more about arbitration clauses and why you would want to have arbitration for some of these disputes, it's important to consider all of these kinds of things in common law jurisdictions and whether you want them in arbitration.
Yeah, Philip, this is basically what I was saying earlier is that, and I agree with Barry that most U.S. Corporate statutes, including that of Delaware, Nevada, Texas, some of the more common ones, do provide for similar types of claims against the company. So it becomes a question of what is more efficient and what is easier, and where are you based, and what is the objective of why would you want to put in an arbitration clause into your corporate agreement.
Yeah. Okay. Roberto, Philip, if there's nothing further to add on this issue, yeah, we good? Yeah, so I thought at this stage, I think in the next part, we're going to touch on procedural issues fairly centrally. So I thought we'd leave that for then. It seems to me the most appropriate thing now to do is to address some of the questions that have been asked on the Q&A. First one is about expedited arbitration procedures. Does anybody see any angle in relation to intra-corporate disputes or corporate disputes in general? Any issues you can see about the availability of interim relief? Roberto spoke about the Italian position where, somewhat surprisingly, Italy very restrictive about the institution of interim relief by arbitral tribunals, actually opened a breach in the corporate context. Does anybody see any issues about why interim relief and, let's say, emergency relief may be inappropriate in the context of intra-corporate arbitration in particular, inter-corporate arbitration as well?
What I'd say is that, from what I've seen, is often these kinds of disputes, a party wants interim relief or wants an injunction. So if you're in a jurisdiction that won't readily consider those applications, you may have a problem in terms of arbitration, because often you're trying to stop the majority from doing something or that's time sensitive. They're real-time disputes. They're not somebody broke the contract and you're suing for damages. There's somebody's going to issue shares, somebody's going to do a transaction, somebody's not getting information. They're all things that can come up that you want some interim relief. So it's a question of whether the tribunal can grant it and whether you still need to go to court, because the tribunals, as with all arbitral tribunals, have a limited power of what they can do in terms of enforcement of their interim orders.
Oh, terrific. Yeah, absolutely. Something to add?
Maybe just to add from my experience, I mean, in Germany, you have usually both available. Usually, even if you have an arbitration agreement, you still usually can go to the state court. And what I've seen so often is that is often the state courts are preferred in that way because it just goes quicker. Because when you talk about the interim relief granted by an arbitral tribunal, you first need to constitute the arbitral tribunal unless you have an emergency arbitrator, and that takes often more time than just going to the state courts right away. Yeah, but that may also have changed a bit now with new rules on emergency arbitrators, but in the past, that was my experience.
Yeah, thanks, Philip. John, Roberto? Well, I think one of the big issues is the fact that you've got this complex array of people who are potentially affected by any order for interim relief, and the odds are you won't have everybody on notice in the arbitration. So in as much as one requires for arbitral emergency relief, to have parties involved to be heard, it's highly problematic. Nonetheless, if in the arbitration rules you get sort of an ex parte right, in as much as I suppose a party is bound by the arbitration rules, that perhaps could be less of a problem. So yeah, I mean, I think that's always going to be looming in the context of any corporate arbitration, and fundamentally problematic. Anything further to say on this question? A very helpful and interesting question asked by Zafar Kalanauri. If not, a second question we could deal with now is from Mohammed Khan. He asks about the ripple effects of the enforcement of an arbitration award involving intra-corporate disputes. So you've got, I suppose it's highly abstract, but you've got a decision, an award, and it's been actually given effect by a national court in a particular jurisdiction. What are the consequences of that? I mean, how is it going to work its way through to to actual effect?
Philip, I would say that the question is the question I already posed. Is whether is it possible to have an international corporate arbitration? If the answer is positive, then the international corporate award has the same effect of domestic corporate award, and so the company is bound by the decision made by the arbitral tribunal. Otherwise, if it is not possible to have an international corporate award, the award is not binding on the company. It's a very tricky question, and it entails also another question, in my opinion, which is whether it is always possible to have an international corporate arbitration, or if it is required that the foreign rules or the rules of the institution, which is indicated in the arbitration clause, need to be amended and supplemented by some mandatory provision, some mandatory procedural provision contained in the local law of the company.
Yeah, absolutely. Yeah. Okay, anything further to add on this question? A third question from Athena Stafila is as follows. You've got environmental harm caused by the corporation, and a third party brings an action against the corporation. So to what degree can this fall into arbitration? You've got a third party bringing an action against the corporation for something that's done to harm the environment. Could anybody analyze that first level of questions?
I guess I would have to say that if there's no agreement between the third party and the corporation, then there is no basis for handling this in arbitration. That situation might be changed were the corporation to decide that they would prefer to deal with that issue in arbitration rather than going through national courts, and actually come up with essentially an ad hoc arbitration agreement to deal with that matter. But absent an arbitration agreement between the two parties, there can be no arbitration.
Okay, I think that's a starting point. Now, here's Athena's twist on that. You've got the action against the mother company in a group structure, multinational group structure. It succeeds. To what extent can you get arbitration, well, I guess it's no longer inter-corporation, but it's intergroup arbitration against a subsidiary, which was actually the entity which caused the damage? So this is probably a very common situation. You've got a local subsidiary, classic situation, causing environmental damage somewhere, you know, in New Guinea or in Chile or et cetera. And then you've got a mother company with an arbitration clause in its Articles of Association. Can somehow this claim of the mother company for recovering its losses sounding against the daughter company, the subsidiary, actually end up in arbitration?
Well, actually, wouldn't it be the other way around? The daughter company who is liable to make the payment is actually claiming from the mother company for essentially the funds to make the payment with.
Well, in our hypothesis, and I think it does happen, John, is that you've got, for example, Cape Industries situation in South Africa. You've got your tort action in the UK and England, but effectively it would have been a local company. I don't know if those are the exact facts, but you've got the local company doing bad things in South African mining, for example, you know, polluting rivers, et cetera, and groundwater, et cetera. You know, obviously your defendant is going to be the moneyed, you know, parent company in the jurisdiction where you can actually get a sensible award of damages. So that all occurs, and you get a successful action against the parent company.
But is there jurisdiction to bring the tort action in England?
Well, that's a big question, yeah, and sometimes it's answered in the affirmative. In our hypothesis, we're just going to have to accept it is, because we've got not just an action, but we've got a successful action. And now we're wondering whether somehow that mother company wants to bring an action against, you know, let's say a partial subsidiary to recover.
Philip, I think that the action against the parent company is only successful if it is established that the parent company through the daughter company caused the harm to the water, to the environment, etc. So maybe there's no true cause of action of the parent company against the daughter company.
Okay, yeah, it all depends. But in our hypothesis, we do have a successful action, and the parent company may or may not have been partially, you know, responsible. But here it is, holding the bag, as it were, and there's an arbitration clause in, you know, let's say both the parent company's Articles of Association and in that of the subsidiary company, and they're the same clause, so no issues arise. You know, do we actually have the arbitration clause, you know, binding the subsidiary to the mother company for that sort of action? Well, I suppose it depends on what the arbitration clauses say, doesn't it? You know?
Yeah, I think yes, also because from the Italian perspective, that would be a tortious claim of the parent company against the daughter company, not a contractual claim. So it could be possible to have corporate arbitration only if the arbitration clause expressly applies with respect to non-contractual claims.
Okay.
In Germany, statutory arbitration clause usually does not extend within the company, meaning it's really only within the mother company, the disputes that would be subjected to arbitration, and therefore any dispute between a mother and a daughter company, may they have statutory arbitration clauses in both their statutes, and may they be the same or similar and so on, would not subject such a dispute to arbitration unless there's a specific agreement between these two companies on which that could be based.
Yeah.
It's not relating to the affairs, the internal affairs of the corporation, but what was going through my mind is the derivative claim. So in this kind of situation, leaving aside arbitration, you might have somebody seeking to bring a derivative claim against the directors or for their mismanagements, leading to the problem. That gets into the whole area of arbitrability of those kinds of claims, derivative claims, which is an issue that I haven't seen come up that much in these kind of contexts.
But Potentially, if the directors or the managers were party to the shareholder agreement, then that might, then they might be involved.
All right. Well, how about this? The parent company, we call them mother company, but that's not sort of gender stereotyping. It's just that in Gesellschaft and Filiale, they're both feminine, aren't they? But I guess in English it is parent company, so I'll try to stick to that. So yeah, you've got the parent company, which is acting as a shareholder. It's holding the bag. Isn't that going to get it an arbitration under the arbitration clause of the subsidiary?
I guess it's going to depend on what that clause says, and we sort of wiggle our way in and out of it. But if we come to talk further about arbitration clauses, it's really important that the clause, if you want it to be able to encompass all of the kinds of disputes that can arise, that be drafted sufficiently broadly.
Yeah, absolutely. Much is going to depend, as you say, Barry, on the wording of the arbitration clause. That was a question from Athena Stafila. Many thanks, Athena, for that fascinating question. As everybody sees, I mean, this is really a greenfield area of law, and there are many issues that we're exploring at this stage. Right. So now we're moving on to a question from Eric Decker about the writing requirement in Article 2.1 of the New York Convention. So is that satisfied in as much as you've got an arbitration clause in the Articles of Association? Is that writing requirement satisfied?
Yes.
Yes, I think there very much is. Yeah, I mean, Articles of Association are not just in writing, but they're very formalistic documents. And so, yes, I think at that level, as Barry says, I think one can be satisfied. Would someone like to add any other wrinkle that I'm missing?
Well, I think the other question would be is to what extent might somebody have signed up for those Articles of Association? And again, they might say that the fact of being a shareholder means that you have agreed to these Articles of Association, but that could be a matter of dispute if you had not had noticed that. And again, going back to something I think Roberto was talking about was whether there was proper notice.
Yeah, I like that. Yeah, thanks, John, for that. Yeah, that does advance the analysis. In Switzerland, for example, the writing requirement isn't applicable to everybody as long as it exists between some parties to the arbitration. So that's going to depend, isn't it, on the home arbitration system where the seat of the arbitration is, but also, of course, where the arbitral award is sought to be enforced under the New York Convention. Yeah, so interesting question, Eric. Many thanks for that. I think we can move on to the next question. Very interesting. So if you want to disturb the business of a company, you initiate arbitration proceedings under an intra-corporate arbitration clause. What tools can be used to prevent that? Who wants to address that? And this is from Yannicka Basuria, this question. Well, the same issue arises, doesn't it, with regard to actions before the courts? Is it easier to run an arbitration than litigation before courts and disturb the business of the company? In some ways, I guess it is. You really slow things down as the tribunal is being constituted. You can ward off to some degree interim relief. Barry pointed out that many corporate issues require an immediate solution. So there is potential for abuse here.
The difference being that if you're commencing an arbitration, I'm assuming you're commencing an arbitration because you're a signatory to a shareholders agreement or otherwise bound by the Articles of Association. But if you're commencing an arbitration, you still have to put basically skin in the game. You have to pay the filing fee. You have to pay probably your counsel. So there are costs which you're going to have to bear. If you're willing to bear these, yes, you can force the company to deal with the arbitration. But I would almost say from a company's point of view, it might be easier to deal with an arbitration like this rather than with a court case, which would be public and potentially more invasive.
I was just thinking the same thing, John, that one of the tactics that the busybodies will use is publicity. I mean, they want to create public pressure, get publicity. If the arbitration clause has a strong confidentiality provision, you're going to be denying that ability. Now, the busybodies often aren't members of the corporation, but where we're talking about situations where the busybody would be a member of the corporation, otherwise they wouldn't be bringing an intra-corporate arbitration. So you could have a disgruntled minority shareholder who decides to go public on his or her court proceedings. If you've got an arbitration clause and it precludes going public, then that removes one of the tools that the busybody might have available.
Yeah, from the Italian perspective, it's a necessity to use arbitration. So it's not useful to know in 2024 that the balance sheet approved in 2003 were null and void. So I think that the backlog and the timing of Italian courts are known all over the world. So the use of corporate arbitration is needed to have an enforceable decision when you need an enforceable decision, and not some decades later.
Mhm.
Well, that comes back to the reasons for arbitration. And if you've got in a jurisdiction, and so many now have started to follow the model of taking forever, you've got a problem. You know, at one time.
Yeah, but with a contract, if you are litigating on a contract, maybe the contractual relationship was already ended. In corporate disputes, it could be that the corporate relationship is always useful, and you need a decision to have the company continuing performing its activity. And so the need for a quick decision is more stricter, in my opinion, in that field.
The terminology that somebody developed was, real-time litigation or real-time, and those situations really, you can't wait.
Yeah.
Yeah. Philip, you were about to say something, weren't you?
Yeah, I just wanted to add, I think I fully agree with everything that has been said, also from a German perspective. There's no silver bullet to avoid such disturbance. However, if you have it, it's better to deal with it with arbitration than on state courts. That's definitely also true in Germany. Many reasons have already been given. I just want to add also the length of the proceedings and the predictability, of the outcome, but also of the length of the proceedings, because if you want to drag this on in German state courts, you have ways to do this over years, and that's definitely not what you want.
Yeah, absolutely. Yeah. And as I think you'll probably be saying, I don't want to preempt this, in the arbitration clause, there's ways of warding off these difficulties in arbitration, making, for example, provision for very fast arbitration. I think one of the concerns, if I may, about intra-corporate arbitration and the potential for abuse is that there are so many open issues about whether things can be arbitrated and by whom. And because there's this degree of grayness, let's say, you could probably keep an arbitration going just on jurisdiction for quite a long time and, cause a lot of mischief. What do you think about that vis-a-vis what you can do before courts, where the law is settled? I mean, we've got some very clear law on what the courts can do for you and for whom.
My initial comment to that, Philip, is that depends a lot on your arbitral tribunal. I mean, arbitral tribunals, in my experience, can deal with jurisdictional issues quite quickly. Again, they have to be a bit forceful in doing this, but they can put those issues to rest very, very quickly if they wish.
Yeah, that's true. If you get the right tribunal, they can, well, you know, things are, some questions are legitimately difficult and they're going to need to grapple with them. But yeah, you're right. There's better and worse approaches to it.
But it does emphasize the point that looking at arbitral seats, that in some jurisdictions where you don't have a clear right to be bringing whatever the kind of claim is in arbitration, you're going to wind up, or there's a high risk you'll wind up in court fighting over whether the tribunal had jurisdiction ultimately. So, if you're in a jurisdiction where it's quite clear that these particular kinds of intra-corporate disputes are arbitrable, then you don't have that problem. But it's the same with, I guess, any arbitration clause. You want to look at where you're arbitrating to make sure that you're not buying yourself some litigation on top of the arbitration.
Yeah. Shall we move on to the next question?
Yep.
This is a question from Mohammed Khan. Yes, it is. Yes. So it's, just a consideration of the various dispute resolution mechanisms beyond straight up arbitration and their applicability to corporate disputes, in particular inter-corporate disputes. For example, ARB-Med, Med-Arb, you start with mediation, you move into arbitration, you start with arbitration, you move into mediation. You might even do that within an arbitration. Any particular issues arising in the context of intra-corporate arbitration, intra-corporate disputes?
I'll get this started. I think it's a very good point. And I actually would say if you're going to put an arbitration agreement into your intra-corporate your corporate documents, you probably would want to have what I would call a tiered resolution clause, which provides for negotiation, mediation, then arbitration. But as he was saying, you could do it any different way. But I think it's always good, especially in these corporate type things, to at least provide for the possibility for mediation, to raise it with the parties, because that helps keeping the disputes, it helps managing the disputes and possibly avoiding having to go to arbitration.
Yeah, I agree with John. I mean, to the extent that one of the great benefits of mediation is preserving relationships. People involved in a corporation together are in a relationship, and if that can be sorted out through mediation and avoid some of the not only the remedies that a tribunal or a court for that matter could award, but to keep the corporation functioning. I mean, what happens in a lot of these situations is you wind up, if not in a legal deadlock, you wind up with everybody spending a lot of time fighting internally and not getting the business of the corporation done. So building in mediation, I think is in your drafting is important. I would go one step further, and there's a lot of talk in some industries about dispute avoidance, and that is bringing in mediation in construction or project type situations where the mediator helps parties resolve a situation before it becomes a dispute. And I can see that there could be a role in some corporate situations for that kind of thing. When the problem just starts to emerge, getting on top of it with the assistance of a third party may make some sense.
Yeah. But there's nothing that inherently prevents anybody from doing Med-Arb, Arb-Med in the context of intra-corporate arbitration, intra-corporate disputes. On the contrary, as Barry says, it's actually very often a good idea. I don't see any impairment to going into mediation at all. Mediation is consensual. If you come up with an agreement at the end of it, it binds the people who agree. It's very clear. And it's a nice solution. With everybody's agreement, we'll move on to the last question we have here, and then we'll proceed with the rest of our program. I see the hour advancing, and I think we don't want to try everybody overly. No, I think we've covered all our questions, it seems. Good. Okay. Thank you very much all for your questions. Don't hesitate to ask further questions. And so we'll move on to our more sort of critical aspect of this program. Are the complications arising in arbitration under some corporate forms so difficult that arbitration does not or should not be available for them? We have actually commented quite a lot on this sort of thing, but anything further to add? Okay, everybody's content. Yeah, John. Okay, we're all good, huh?
Oh, no, I'm fine with that.
Okay, so perhaps our last set of questions is about what can be done to prepare for intra-corporate disputes in arbitration systems, arbitration rules, and arbitration clauses. So let's start with arbitration systems. How does your particular arbitration law system address the challenges in arbitrating intra-corporate disputes? And what improvements can you suggest to accommodate corporate disputes? So let's do it this way. Let's go upon our original order and start with Philip. German arbitration law. So is it doing a good job in addressing these sorts of issues in intra-corporate disputes? And what could it do better in the German context? You can't start from
I would say no, because if you ask, how the German system accommodates arbitration, intra-corporate arbitration, the short answer is it doesn't, because there are no special legislation exists. All that we have is for court rulings, and those are limited, as I mentioned before, to limited companies and partnership. So there are quite a few questions which are open. I mentioned before the question, can companies limited by shares have statutory arbitration clauses at all? Can they be introduced by a majority vote? What happens if requirements set by the Federal Court of Justice are actually observed in the proceeding, but not ensured by the clause? According to the current ruling, the clause would still be invalid, even though everything the clause was supposed to do actually happened, like inform shareholders, make sure they can participate, and so on and so on. So I think there's much that could be done to be improved in the German system. Unfortunately, as you may know, Germany is about to reform its arbitration law. However, all these questions are not at all on the table, and I don't really know why they are not. There are a couple of other questions which seem less relevant to me subjectively, but so there's nothing. Unfortunately, there's no improvements in sight, even though there is a reform currently underway.
Okay, Barry. Thanks, Philip.
Well, not aware in common law jurisdictions that there, at least can't think of any where there are provisions that are specific to intra-corporate disputes. Certainly in the English law reform exercise that has almost reached its conclusion, I'm not aware there was any discussion of that topic. I know there was the idea of trust arbitration raised, and that was left for the reform of trust law, not dealt with in arbitration. But I'm not aware that it's been considered. And one of the things I always say is, if I've been on a panel and learned something, it's been worthwhile. And I think one of the things I've learned on this panel is that there are jurisdictions, whether it's in statutes or in other ways, have done things to facilitate inter-corporate arbitration. And I think it would make sense, at least for it to be considered in common law jurisdictions. Maybe it's not necessary, but I don't think it's been thought through enough.
Yeah. All right. Yeah, that's very important point. So it's the jurisdictions like Well, Switzerland is certainly thinking about it, and in Italy, as we've heard from Roberto. But Roberto, thanks, Barry. Roberto, what do you think about Italian arbitration law?
I think that we have a quite good legislation. In any case, some improvement would be needed. So, for example, in Italy, we have a very strange animal, which is called arbitrato irrituale. You have arbitration proceedings resulting in an award that does not have the effects of a binding decision. It has the effects of a binding contract. So, if the losing party does not abide by the award, you must obtain a new enforcement decision by the court. These are remnants of the past when arbitration was regarded with suspicion, but it's used in corporate arbitration as it could be useful as it is regarded as something less intrusive in corporate matters and decisions. But the rules applying to arbitrato irrituale in corporate matters are not so clear. So, for instance, it is not clear whether it is possible to challenge a resolution of the general meeting. And so some clear guidance and some intervention by the parliament would be very useful.
All right. Thanks, Roberto. And now, John. John, your mic.
I don't think I really have anything to add to what Barry was saying, because under, from what I'm aware of in the US, there are no specific legislate or statutory provisions dealing with arbitration in the intra-corporate context. And I don't believe there are in France as well. And I guess where I would go is almost start to go into your next question, and is that the arbitration institutions could start to possibly develop this area by working on specific rules that would assist intra-corporate arbitration, which I know some of the
Yeah, let's do it now, John.
They're going to be addressing that. So I did want to say one thing though, because I think I sent you a law review article, is to a certain extent. What's that? Yeah, which I sent it to you last night, so I didn't think you got through it. But
No.
basically, what it was saying was that there is talk going on in the United States about how to possibly get binding arbitration into publicly traded companies, basically to deal with shareholder derivative actions, which are essentially class actions against the corporation, which can result in very extensive awards. And this is, to a certain extent, it's a developing area of law. I don't think there's been much on this. The article I sent you basically it takes the position that state corporate law probably can deal with this problem, but it's a new area of law, and it's really not been litigated in the United States.
John, don't you have an issue because of your strong protection of the right to a jury?
That's true. So that is true too. So again, it's people are thinking about it, but not much has been done on it.
Okay. Yeah. Interesting. Yeah. So John introduced a topic rightly about what can be done in arbitration rules and what is being done, to facilitate intra-corporate arbitrations. Who wants to begin? Philip, do you want to talk about the DIS rules?
Absolutely. So the German Arbitration Institute has come up with a set of rules specific to corporate disputes. However, one needs to know the notion of corporate disputes is a bit more narrow than probably usually in an international context. What is meant is disputes between the company and its shareholders or among the shareholders, not necessarily with the bodies. So these set of rules address these kind of dispute, and they accommodate the rulings of the Federal Court of Justice. So if one wants to introduce in a German company an statutory arbitration clause, it's a good idea to refer to those. You need to keep in mind, though, it's not sufficient to refer to the general arbitration rules of the institution. You also need to specifically refer to the specific rules for corporate disputes, and then you're pretty much on the safe side. So that is very helpful, yeah.
Philip, that's right in the DIS rules, the requirement that you need to actively incorporate the special rules under the DIS arbitration rules in relation to corporate arbitration.
Yeah, exactly. So here what you're seeing is the general DIS rules, and then you have the annex. If you then have maybe the here exactly one before, I think
Sorry.
one at the beginning. Here you see you have 5 or a couple of annexes. And yeah, there you find the Annex 5.
Right here.
Annex 5, exactly. Supplementary rules for corporate disputes. So if you want to incorporate that, you need to refer to the general disputes, plus also specifically to these supplementary rules for corporate disputes.
And what do they cover?
Yeah.
They cover disputes between shareholders and the company or among shareholders. So typically about the validity of resolutions. You can find that in Article 2, I think, to 1. That is, it's the idea or the whole thinking in the German system is, based on these court rulings. And they basically said initially in its first ruling, for these kind of disputes, you need to have an inter omnes effect, what also Oliva mentioned before. That you have, not 2 parties to be bound by, you have to be a couple of people, potentially very many, or the shareholders be bound. And if you have this issue, then you need to have these special rules in place. That's also why this article is called Inclusion of Concerned Others. Concerned others means other parties that might be affected by a decision, but are not actually parties to the dispute or who started the dispute.
Yeah. Any other rules that anybody would like to refer to?
I can refer if you want to the CAMS, the Brazilian rules, the CAMS CCBC rules.
Find that, Barry.
Which if you want to put up, but essentially it's a set of rules that the main arbitral institution in Brazil, which is large and very busy. So it has a set of rules and requirements for when they apply. The arbitral award possibly affects not only the claimants and respondents, but others, which they call affected third parties. The nature of the disputed legal relationship requires a uniform decision. There we are. And the bylaws or articles contain a clause. So that's when those rules apply. And then Article 2 sets out the kinds of disputes, which aren't surprising. I didn't include Article 3, but Article 4 is that, again, the same kind of provision as we just saw in the German rules, the notice to affected third parties. That seems to be, if you wanted to pick out one feature of specialized rules for corporate disputes, it's this affected third parties or whatever they're called, and inviting them to partake in the arbitration proceedings. Interesting, there's an English court decision where it was raised that one of the problems with arbitration dealing with these disputes is parties that are these interested parties, and the court perhaps somewhat unhelpfully said, without giving any direction, well, they could be put on notice, or they could be given notice, and their input sought. Having rules obviously makes that more practical. And then Article 5 refers to what I was talking about earlier, the public companies. And Article 10 is interesting. It lets the affected third parties join into the arbitration. The affected third parties may join the arbitration at any time in the state it's found when the request for joinder is filed. So it allows basically the affected third party to sit on the sidelines, and then if it looks like there's a reason, apply to join, and they step in without being able to affect what has already taken place. And it carries on. And then Article 11, the affected third parties that don't take part may request a personal non-transferable link to access all the acts until the conclusion of the arbitration. So that, so basically they can have a private window on what's going on in the arbitration. It shows some innovation in trying to accommodate these what they call affected third parties. And as I said earlier, the exact same concept is what was in what we just saw in the German rules.
Yeah, that's a big issue. Yeah. Anybody else want to intervene at this stage? Because I could also mention the Swiss supplementary rules under the, the Swiss rules.
Why don't you? Because I thought they were interesting.
Yeah, this is an interesting document. Sorry, just bear with me.
And if you don't mention them, your countrymen will say that you weren't promoting the jurisdiction enough.
That's true too. Let me just see if I can, add this. Yeah, so the Swiss rules, as you know, of arbitration, don't actually contemplate expressly intra-corporate or corporate disputes. But in 2003, the Swiss Arbitration Institution, the Swiss Chambers or Swiss Court, promulgated supplemental Swiss rules for corporate law disputes. So one of the interesting things about these, which you see on your screen, is that they apply automatically in as much as a Swiss SA or a Swiss SARL, the two principal corporate forms, have actually chosen the Swiss rules. So you're that corporate form of a Swiss company, you choose the Swiss rules, then you get by Article 1, you get these supplemental rules, huh? Okay, so it's right in there. And as Barry says, one of the major issues is notification to people who haven't been cited in the arbitration. So there's a massive obligation, information regarding the commencement and termination of the arbitration procedure. In fact, those notification requirements, they continue right through the arbitration into the award. Another issue is how the arbitral tribunal is appointed. And as we've heard already, it was from Roberto, generally speaking, where it's messy, you're going to get the institution appointing all the arbitrators. Okay. There's also provision about the involvement, not just the information to other parties, so the various capacities in which they can be involved. There you are. So these are out there. Now, you're probably thinking, I'm not a Swiss SA or an SARL. I don't care. But the reality is, it seems to me that you can actually expressly contract into the application of these rules, with or without the application of the Swiss rules themselves. And they are very helpful indeed, as I mentioned, in facilitating corporate arbitrations in general, intra-corporate arbitrations in particular. Okay. So on arbitration rules, have we covered everything we wanted to say, and should we move in the few minutes remaining to us on arbitration clauses? I think it's probably advisable at this stage. I see no objection. So what can be done in arbitration clauses? What should be done to facilitate, to prepare for intra-corporate arbitrations? Who wants to begin for a few minutes?
I've been trying to think about, you've got the list of all the things you should be considering in an arbitration clause. Is there anything different? Obviously, the seat, confidentiality, the whole host of things that and you know, maybe we've seen it in the with the rules we just looked at, that there's some considerations that you could put into your clause that ordinarily you wouldn't think of. You could also put into your clause something around remedies if it's not otherwise provided. You could put into your clause something around, you know, obtaining the views of others. I'm not saying that all of these things should be put into a clause, but you know, there's things that drafts people could think of. The problem, of course, being that most arbitration clauses are done in transactions at the 11th hour, and nobody thinks of any of this stuff. But you know, if you're going to have an arbitration of intra-corporate disputes, you aren't in that 11th hour, 11 minutes to midnight trying to do a commercial transaction. You're incorporating a company, so you're drafting articles, and so you do have the time to be more thoughtful of it, and it's probably worth taking that time, and the drafts people consulting with arbitration specialists rather than pulling out a standard clause, which you know, one of the issues, and it came up in a Hong Kong case, is the court said, well, you know, these kinds of intercorporate disputes were arbitrable, but your clause doesn't cover them. So it's, you know, making sure that the scope of your clause is broad enough, because it's not just enough to say, you know, all disputes concerning this agreement, because it's not this agreement. So you want it to be, and it may be broad enough if you use the standard clauses of an institution, you know, arising out or in connection with this relationship and so forth. But you want to make sure that if you are trying to make intra-corporate disputes arbitrable, that your clause is broad enough. And conversely, I guess if there's things that you don't want to be arbitrable in the intra-corporate sense, then you need to carve it out.
Yeah, absolutely. So, are we getting towards the
I
end?
would add, Philip, if I may, that from my point of view, Italian practitioner, in the Italian notary's boilerplate is that the arbitrators are appointed by the chair of the court or the chair of some professional association, such as accountants association or the notaries association. I think that more careful attention is required, as Barry pointed out, in drafting the clause, because in doing so, in accepting the boilerplate, you face the risk that the appointed arbitrators do not have any experience in arbitration proceedings. They are practitioners known to the court, so they are litigation practitioners. Or they are practitioners known to the accountants or notaries, so they are mainly transactional practitioners. And this entails further risk concerning the stability of the award. So I would suggest, as Barry said, to involve an arbitration practitioner also in drafting the arbitration clause.
Okay. Well, I thank you, Roberto. I think we're going to need to stop it here with apologies to Philip and John. This is obviously another major issue. We've covered a lot of ground. John, sorry, you're on mute. I apologize.
I wanted to repeat something I've said earlier, include the possibility of mediation as well.
Yeah,
And
okay. Yeah,
and
that's
I
come up.
stop
Yep, absolutely. You mentioned it. Barry mentioned it. I think it's an excellent idea. Absolutely. That can be done, as you know, yeah, in corporate statutes. Yeah, so we've covered a lot. There's obviously much more to say, which we haven't time to do. You know, this is I think it's a terrific topic. Barry mentioned he's learned something. I've certainly learned a lot about intra-corporate arbitration and the various arbitration aspects of it. And so I'm grateful to our panelists. I'm grateful to those listening to us. Thanks for joining. I wanted to mention that This idea of having comparative arbitration law seminars is from the former chair of our European branch of the Chartered Institute, Jacopo Monacci Naldini. I think it's really a super way to approach these things because, as we've seen today, this clash of perspectives really helps to elucidate the ideas. And so I am grateful to Jacopo as well for that. I'll mention lastly that the next installment of our 2-webinar series is on the second of the webinar series, which is on the fundamentals of counsel practice. And this one's on teams and file management. And that is on the 12th of November at 10 o'clock Central European time. We invite you to join us for that. Many thanks to all, and we'll leave it at that.
Thank you, Philip.